and we're going to try and monitor and get in as many questions as we possibly can within the next hour. So we're going to begin with my colleague, Professor Lawler, and then I'll make a few brief comments, and then we'll bring in our pitch hitter, Professor Cook, and then we'll start answering your questions, as many as we can. So, Professor Lawler.
Good afternoon. I also just wanted to clarify that the order in which we're going to talk a little bit follows the chronology of how an investigation and sort of going through the process, where start to finish. And so I'm going to talk a little bit about the search warrant process, the execution of the search warrant. Professor Price is going to talk a little bit about the issues of self-defense that got raised. And Professor Cook is going to talk about some of the issues related to the grand jury, among other things that come out. So I wanted to talk first about sort of four big picture issues related to the search warrant. So one of the things we know from Attorney General Cameron's remarks is that the search warrant issue is still being investigated by the FBI. And so the issues arising from this part of it have still not been resolved and are still under investigation. So there's a few questions that have come up with regard to the search warrant itself. The first question has to do with whether there was probable cause on the face of the search warrant. So what happens in a case is an officer will go, law enforcement officer or an agent, in this case it was state law enforcement, I believe, to a judge with an application for a search warrant, laying out the place to be searched and the items to be seized based on their investigation. And so in this particular instance, an officer who was not one of the officers charged or even investigated for the shootings, a different officer, put together a search warrant based on a big drug investigation they had been doing. And in fact, there were 5 search warrants that he put together that were essentially similar in what they had in them, other than the location to be searched. And so one of the questions is, and it's a question that comes up more broadly in criminal procedure, is whether the judge basically rubber stamped or didn't rubber stamp in this instance, the search warrant, because there were some questions that got raised. For example, was there any real basis with regard to Breonna Taylor's apartment to believe that drugs were actually being sold from that apartment, right? We don't really have any basis to believe that. And so had a judge, whether it was a magistrate or a district judge, been looking at, sort of beyond the face of the warrant, asking a little bit more questions, that's something that we think might have been explored, right? Was there any indication of anything going on illegal at that apartment? Again, if the judge had asked some questions, hopefully they would have figured out that there wasn't much to believe in with regard, again, to Ms. Taylor's apartment. So that's one of the questions. One of the big picture questions is what degree of interrogation did the judge in this case use with regard to what they were presented with the search warrant? A second issue regards whether the officer made misrepresentations in the warrant. So one of the things that was in the warrant was some indication that there had been some packages mailed to Breonna Taylor's apartment, and some indication that they had talked to postal inspectors, United States postal inspectors, who actually have their own investigative agency, about those packages. Later, after the warrant was executed and Ms. Taylor was killed, an agent from the United States Postal Agency said, look, if they had talked to us, we'd had a tip before to investigate them. We'd investigated, and that we have found nothing suspicious about the packages going to her apartment. I heard somewhere that they also had found, they had been clothes and shoes basically going in the packages. And so there's some indication that perhaps there was some misrepresentation on the face of the warrant, which is also problematic. A third issue has to do with the execution, right? You've heard probably a lot of talk about the no-knock versus the knock-and-announce warrant, and we can talk more about that. But essentially, the understanding we have based on publicly available information, and that's the caveat to all of this, is that some of this we still don't know, is that they had initially asked for a no-knock warrant, which would mean that they just execute the warrant, the agents go in without announcing their presence first. But that a decision was made by higher-ups the day of the execution to go ahead and knock and announce. One of the things that is problematic and has led Louisville to go ahead and ban no-knock warrants, in the search warrant itself, the justification for the no-knock was essentially that there's drug trafficking crimes going on and they're dangerous. And if that's going to be a justification for a no-knock warrant, then that's going to mean almost any warrant, and in any drug case can be no-knock, which I think is not what the law is intended to be. But the other issue is just with no-knock warrants more generally, right? I mean, with a no-knock warrant, you ensure that the person inside has no opportunity to come to the door, so that their door does not get rammed down by a battering ram or some other way, which inevitably is going to lead to the door and the door frame being broken. And you assume, and you decrease the chances of injury or violence because you at least give the person a chance to figure out who's at the door, as opposed to having no idea who's coming into their house, with suddenly a battering ram, banging down their door, which raises the opportunity for violence on both sides, right, and for injury and for death on both sides. Then one other thing that has sort of come out of this, and one of the reasons that there has been attention paid to the issue of whether the officers knocked or didn't knock, and what they knew or didn't know going in. So one of the things that Attorney General Cameron says is these three officers were not the officers who, went to ask for the warrant in the first place. That matters because it means it gives them a good faith defense. If they were operating by looking at what's, the face of the warrant seemed legit to them, they don't know anything about the background to it. The fact that they didn't know that background gives them a good faith defense, which my students keep having lots of questions about, understandably, right? So those are kind of the big picture issues about the warrant itself. Some other issues come out with regard to the execution of the warrant, things that were done kind of not according to protocol. So one issue that's raised is that, usually speaking, when officers go in to execute a search warrant, they have an ambulance on standby. Usually that ambulance is supposed to know what the route is to the nearest Trauma 1 medical center from where they are. For whatever reason, the officers in this case dismissed the ambulance, which we now know became problematic for numerous reasons. So if you listen to some of the recordings that have come out, after Sergeant Mattingly was shot, they tried to get the ambulance to come in. The ambulance couldn't get in. The ambulance tried to drive through the gates to the apartment complex, got stuck, couldn't get in. And that's before, or at the same time that they were learning that Breonna Taylor had been shot. So, one of the questions is, why did they get rid of the ambulance in the first place? Unclear, given everything that followed, whether that would have made a difference for Ms. Taylor. But it's an open question as to why that ambulance wasn't readily available. The other issue raised has to do with the amount of time that passed before anyone came to try and aid Ms. Taylor. The fact is, the officers initially did not know they had shot anyone, but Mr. Walker called 911 very quickly after she had been shot. And so they were on notice at that point that she had been shot. And then about 20 minutes later, was the earliest time that anyone came in, which is, raises the question of whether there's a failure to render aid in a timely manner. Then the issue of excessive force, as much as we would like to be clear-cut, is a little bit complicated. So we know that from Attorney General's press conference that 32 shots were fired by the officers. We know that 6 of those came from Sergeant Mattingly, and 16 of those came from Detective Cosgrove, who were standing in the hallway of the apartment. And I'm going to put aside for a minute Henkeson, because he did his own thing and went out into the parking lot, and nobody, I think, has raised any questions about the problematic nature of what he did. But so the question is really, does it seem like those 22 shots were excessive? And most law enforcement, so just taking a step back, law enforcement are trained, if they get a shot fired at them, and in this case, I don't think there's any dispute that Mr. Walker fired first because he thought somebody was breaking into the apartment. So he fires first. Officers are trained to return fire until the threat basically is minimized, right? And that raises its own question, obviously, in and of itself, that's what the training is. That's what the training is. And so, in and of itself, the 16 shots or the 6 shots might not have raised an issue. The question that gets raised by the 16 shots is whether Cosgrove had the time to basically took the time to reload, right? His clip was expired, took the time to take a new clip, put it in which case he probably should have realized that there was no longer a threat. Assumedly he was, hearing other shots, so maybe had some confusion about it to give him the benefit of the doubt. Whether we should or not is a different question, but the issue of excessive force is more complicated because of how the training happens. So with that, I will turn it over to Professor Price to talk more about the issues of self-defense that get raised also based on what happened at that point in the apartment.
So my comments on self-defense are going to be relatively brief because we already have questions that are entering the Q&A. And we encourage you to do that, not to follow the chat, but to put questions into the Q&A box. So I can tell you, and my colleagues would agree, that it is getting harder and harder every year to teach self-defense, in part because there's been a lot of legislative activity changing the rules as it relates to self-defense. So if we remember the case that really inspired the movement for Black Lives, the Trayvon Martin case, a lot of the discussion was in the evolution from what was called the Castle Doctrine, which was a traditional understanding of self-defense that actually suggested that you should make every attempt to retreat to safety before one uses strong for any force, or particularly force akin to bodily force, to defend yourself, and a transition in many jurisdictions to stand your ground. And although even in jurisdictions where stand your ground was not adopted, this question about how one defends themselves became more complicated because of the changes around this questions of retreat, around what constituted aggression. If one adds into the mix the lawful people who have a lawful permit to have a weapon, which Mr. Walker had, then what we have is a scenario where there's a potential, when police serve warrants, that everyone is armed. Now, in the law in Kentucky, it says that you are justified to defend yourself in your dwelling when you believe that someone is unlawfully entering. But there are restrictions on whether or not you can use that when the people who are entering lawfully are peace officers and when they announce themselves. So much of the question of self-defense goes to the question of whether or not there was an announcement by police officers at the time. And this is heavily disputed. There are also rules that are determined largely by the Fraternal Order of the Police and some legislation in Kentucky that says that police officers cannot be or do not have to submit to questioning or to provide statements within the first 48 hours. But Mr. Walker, who was interviewed immediately after being taken into custody, says that they never heard an announcement. And of the 12 witnesses who were found in the apartment complex, only one of them testified that they had actually heard the police announce themselves only after they had been interviewed multiple times. So part of the problem in assessing self-defense now is that everyone is armed. And when everyone is armed, every person on the other side of the gun, even if they have one, looks like they're defending themselves. So part of, I think, the necessary questions that goes with this case, and if we think back to the case of Philando Castile, who was unarmed, but announced to police officers that he had a license, he was lawfully permitted to carry a weapon, and was shot anyway when he was unarmed, is what does the right to these laws around the lawful carrying of weapons or concealed carry or permits to have a firearm mean for African Americans when they are not in police uniforms? So I'm going to turn it over to my colleague, Professor Cook, and then we will start taking your questions.
Thank you. It's always a privilege and an honor to sit on a panel with my illustrious colleagues, Professor Lawler and Professor Price. So this summer, I was bombarded by people from all walks of life coming up to me and saying, we don't know why Black people are so upset. We don't know why the world is so upset. So we had Ahmaud Arbery, we had Breonna Taylor, and then we had George Floyd, and we had a lot of people that were sort of wondering, why is the world upset? Now, we had that same sort of discourse and discussion during slavery, right? So you subject a group of people to unbridled torture and brutality, and people are arguing, well, we don't know why the enslaved are upset. We had the same discourse and discussion during Jim Crow, right? So you have Black people drinking from a spigot and white people drinking from a fountain, and people don't understand why Black people are upset. You've got Black people that can't come into the restaurant, you've got white people who can eat in the restaurant, and you've got people who are saying, we don't know why Black people are so upset. So if I don't impress anything upon you today, I want to impress this: the level of rage right now and why. So The first thing we have to do with the Breonna Taylor case is to ground the case in a very rich, rigorous, robust discussion about race. It is unavoidable, grounded right into race. But I'm going to give you some tools in which to engage that discussion, and it's called racial parallaxis. If you're wondering if the case has to do with race or how much race has to do with the case, engage racial parallaxis, which is where you change the race of the actors involved and ask whether you're going to get the same outcome, okay? So we're not dealing right now with a crisis. This is how it works. We're not dealing with a crisis in which Black officers are disproportionately killing white people. We're not dealing with a pandemic or an epidemic of Black officers killing white people. And if we were in the middle of a crisis of Black officers killing white people, I don't think we would put signs in our yards that would say, we love and respect the police. We're on board with that agenda. And in the off chance, next slide, in the off chance that an officer, a Black officer, does kill a white victim, that officer gets 12.5 years in prison, and the victim's family gets $20 million. So the next thing that I want to do with this case is to ground it in historical and material reality. The historical and material reality of this case is that the United States is the most carceral nation in the whole of human history. No civilization now, no civilization in the past puts more people in prison than the United States. We are a country of experts of putting people in prison. As a former federal prosecutor, we are experts at putting people in prison, except when white officers kill Black people. Then suddenly, prosecutorial zeal gets weak in the knees, and our zealousness for prosecution starts to falter. And then what we see are prosecutors who become the best defense attorneys you've ever seen. You see prosecutors putting cases into the grand jury that are better than any case a defense counsel could have put on in trial. Now, in order to understand the impact of the statement I just made, I need to give you a very brief primer on the grand jury process. So, next slide. When you watch Law and Order, you are seeing the petite jury. That's the 12 men and women who make the ultimate decision about the defendant's guilt or innocence. And this burden of proof is very high. It's beyond a reasonable doubt. The grand jury is a very different entity. It is a completely different entity. It is trying to decide whether there is enough evidence to charge the defendant, whether the evidence rises to the occasion of what's called probable cause, a much lower standard. Is there enough evidence to simply make an accusation against the defendant? Now, in the grand jury, the defendant does not have a constitutional right to appear or give testimony. Over in the petite jury, the defendant has a constitutional right to appear, to be present, to have defense counsel if he or she is exposed to jail time, to put on proof, and the defendant can be quiet. The defendant doesn't have to say a single word because the burden is on the government to prove the defendant's guilt. Over in the grand jury, the defendant has no right to be there. If he or she does testify, he or she doesn't have the right to an attorney, and the defendant does not have a constitutional right to have exculpatory evidence, evidence that tends to prove the defendant's innocence, presented to the grand jury. As a consequence, prosecutors run the show in the grand jury. And what's more, the rules of evidence don't apply in the grand jury. They definitely apply at trial. So as a result, the prosecution can put in as much hearsay as he or she wants. It is hearsay heaven down there, okay? The prosecutor is in complete control of the evidence. The prosecutor gets to decide what witnesses are going to testify, what form the testimony will take, the evidence that will be in front of the grand jury, or how little evidence there will be in front of the grand jury. The prosecutor can call one witness and have that witness talk about the investigation that he or she engaged. So here's my next point. Do not fall for the grand jury said trick. Do not allow yourself to be hoodwinked, bamboozled, and led astray about what the grand jury found and what the grand jury said. Next slide. I want to go through 3 cases very briefly, which illustrate my point. Michael Brown, Tamir Rice, Eric Gardner. Michael Brown, you don't have to believe that an 18-year-old boy walks up to a police officer in a marked squad car, and that officer is armed and starts pummeling that police officer, and then takes a pause from the beating he's giving the police officer to take the package that's in his hand to give it to his friend that's walking with him, and then runs away from the officer, but then decides to charge the officer while the officer is shooting at him. You don't have to take that evidence and draw a conclusion that the killing was justified or that the evidence and the testimony of the officer was credible. You get to look at that evidence and make a determination yourself. Tamir Rice, a 12-year-old child, playing with a toy gun in the park, gunned down by the police officer. You don't have to believe for a second that a 12-year-old child's playing with a toy gun in a park is justifiable homicide. Eric Gardner, you saw the video footage. Selling Lucy cigarettes, put into a chokehold. The chokehold itself was a violation of internal police policy. You don't have to believe that that killing was justified. You get to look at the evidence yourself and reach some sort of determination about the case. In this case, there are several material issues of fact that are disputed. Here's one. The cameras were turned off. Did the grand jury hear that evidence? How did the grand jury hear that evidence? All of the cameras were turned off. All 3 officers didn't have their cameras turned on. Was it customary for all 3 officers never to turn on their cameras? Did they have their cameras on earlier in the day, but suddenly the cameras came off? All 3 of them had the cameras on earlier in the day and then it came off? What was the testimony that the grand jury heard about these cameras? Did the officers give the testimony? Did they hear from the officers? Okay. And why is it important? It's important because it goes to the credibility of the officers. Now, average citizens like you, like me, when we're arrested, we have the right to Miranda. If we're in custody and we're being questioned, you have the right to Miranda. Whatever you say can and will be used against you. You have the right to instruct. Okay. Police officers, as Professor Price so prudently stated, in their collective bargaining agreements, bargain for the right not to talk immediately. And if they do talk, they've got to talk in the presence of counsel. Now, law enforcement received training to get you and I at the point of arrest or investigation to waive our Miranda rights. But when the police are in trouble, they are immediately given a cool off period and a period in which to get defense counsel. Why do police want to talk to you right away? Because they don't want to give you the time to start concocting lies, to start getting your story straight, to start talking with a lawyer about what the story is. In this case, we've had officers that had months to coordinate with one another and also to coordinate with an attorney. Then there's another material issue of fact that is particularly important, and this was addressed by both Professor Price and Professor Lawler. It is the execution of the search warrant. We know that the officers went and got a search warrant, and these were officers, allegedly, who were not the officers who executed the warrant. There again, we want to see the evidence. What does it mean that the officers who executed the warrant didn't have anything to do with obtaining the search warrant? They weren't a part of the investigation. They didn't provide any evidence that showed up into the search warrant itself. There again, we want to look at the evidence. But nevertheless, the officer who obtained the search warrant went and got a search warrant and obtained a search warrant that allowed the officers to get rid of the knock and talk requirement, to get rid of what is otherwise constitutionally required when the police officer knocks on your door, to say, we're the police. They put something in that search warrant to justify getting rid of that procedure. And it's usually 2 things. One, the destruction of evidence. Your Honor, if we go knock on that door, they'll flush the cocaine down the toilet. The second thing is officer safety. Your Honor, drugs are inherently a violent crime. If we go knocking on the door, they may shoot at us, but they put something in that search warrant to justify getting rid of the knock and announce. And yet, we find out during the announcement this week that a supervisor told the officers that they had to knock and announce. Well, what was that evidence? And what did the grand jury hear? Was the supervisor's statement recorded over the dispatch? How do we know that these officers heard that particular statement? What was the evidence that the supervisor made that decision? And why did the supervisor make that decision to all of the sudden now tell the officers they have to knock and talk? And why is that important? Well, there's a material issue of fact about exactly how they executed that warrant, because it goes to the level of potential recklessness that they engaged in when they knocked on the door. Last piece of material issue of fact. Professor Lawler addressed this as well. You've got, and Professor Price, you've got at least 12 witnesses that say, we never heard the officers say that this was the police. Somehow, the investigators found one person who said, yes, I heard the police. Now, a couple of things you need to know. Prosecutors and law enforcement are all a part of the same side of the adversarial wall. We are all part of the same fraternity. In my old office as a prosecutor, the law enforcement agents, FBI, police, sheriffs, and the prosecutors would call each other brother all the time. They never called me brother. I don't know why. Maybe you do. Anyway, brother, brother, brother this, brother that. They're all a part of the same fraternity. And there is an inherent conflict of interest when people with the same interests are investigating and prosecuting one another. You need to be aware of that. Okay, so we've got one mysterious witness who says they heard the officer say police. This is homework. You've got 3 law professors all in a row. There's going to be homework. Here's the homework. Watch the Central Park 5 documentary and watch Unbelievable on Netflix. And you will see the way in which investigators can question a witness and either produce evidence that solidifies their predisposition towards the case or squelches the case. I have sat in investigations with officers who will say, I think you've got some parole violations. Why don't you come and talk to me about this case? Are you sure you didn't hear police? You did hear police? What was the evidence that the grand jury heard about this material issue of fact? 3 last points before Professor Price rightfully gives me the hook. In understanding the level of rage here, I want you to think about these questions. What would have happened to Kenneth Walker if there hadn't been an uprising and national attention paid to this case? Kenneth Walker is Breonna Taylor's boyfriend. He was originally charged with attempted murder for firing after the officers when they came into Breonna Taylor's apartment. What would have happened to him in the absence of national attention paid to this case? You would have heard testimony or had evidence from 3 officers who said they clearly announced police, and yet Mr. Walker engaged in reckless behavior and firing off a shot. What would have happened to that case? Then finally, why are officers executing a search warrant at an EMT's home who has 2 jobs in the middle of the night? And as Professor Lawler said, there's some real problems here with the evidence that was used to obtain the search warrant. Last point, do not fall for what the grand jury said and found okey doke. As students of the law, you know you don't listen to characterizations about the evidence. You go and look at that evidence yourself and reach your own conclusions. Thank you.
Thank you so much. So I've already been going through the questions. I'm going to start out with one, and then I'll queue up a few questions for each of you to answer. So there's been a question about why they were able to move forward with the settling the civil suit by the Breonna Taylor's family, even though the criminal conviction the criminal issues had not been concluded. The first thing is that civil and criminal actions can be litigated in parallel to each other, but they don't have to be. you will often find that where there's a significant criminal issues, people will wait for the criminal issues to move forward because it allows the state to do a lot of investigation and ferret out some of the questions around the evidence. But the standard, they're not tied to each other. The fact that you are not convicted doesn't have anything to do with whether or not the family can recover in civil court. In part because the standards of proof are different. In civil court, there's a preponderance of the evidence, and criminal court is beyond a reasonable doubt. So as long as you are able to meet the burden of proof in whatever court that you are bringing your case, then you will be able to recover, or the person will be convicted. In this instance, the family settled. And I think it's important to note that in many jurisdictions, that cities regularly settle multi-million-dollar suits annually, paid for with tax dollars, based on police practices that likely should be reformed. Okay, we have a question about why not murder charges, and why doesn't the failing to render aid lead to its own criminal charges?
I can take a stab at this, Professor Lawler. So there are 6 murder statutes in the state of Kentucky. And part of the problem with this case, a lot of the linchpin of this case is whether the officers could rightfully engage in self-defense. Now let's assume, and again, I'm not assuming anything, but let's assume that the officers who go to execute the warrant are not aware of any problems with the warrant whatsoever. So their mens rea is, their level of mental culpability is they are rightfully at this place at this time. Kenneth Walker is allowed, under the Castle Doctrine, as Professor Price stated, to defend himself. He fires off a round. And now the officers are in a position to raise the issue of self-defense. But mind you, we need to know how that warrant was executed. Did they say police, 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 police? Because if they did not, then that goes to recklessness, and perhaps that would support, at a minimum, a recklessness charge. So what you've got is a problem of material issues of fact surrounding their ability to raise self-defense. If in fact there was no malfeasance that the executing officers were involved in when the officers got the search warrant, and there was no malfeasance with respect to the way in which they executed that warrant, then the officers are legally able to claim self-defense. Now, as a separate issue, there is a problem about the number of rounds that the officers let off in response to the one bullet and their ability to self-defend. So for example, if I'm in a room full of crowded people and someone points a gun at me, I don't get to kill everybody in the room. The problem is that kind of factual dispute is going to be very difficult. This was the dead of night. The officers are afraid for their lives. One officer is shot. There's going to be some questions about how reasonable that conduct was given the circumstances. Now, the indiscriminate shooting that's happening outside in the parking lot by one of the officers, you've got a problem with causation. So according to the announcement, the lethal bullet was fired by a different officer than the officer that's shooting into the windows indiscriminately. Now, let me just say this for a second. This is confusing because the general also said that he had ballistics experts that couldn't come up with a conclusion about what the fatal shot was. It's the FBI's experts that came to the conclusion about the fatal shot. Once again, I want to see some evidence, and I'd like to hear some expert testimony about what this discrepancy is.
And I'll jump in. There's a couple of questions that have been raised about grand jury transcript. So first, I'm happy to jump in with that. So he could disclose more of what happened in front of the grand jury if he wanted to. There's an exception in the law that allows him to, Attorney General Cameron, to, if he feels like it's helpful in preparation for trial or disposition of whatever happened. He seems, I think, unlikely to do that. You can, somebody asked if you could pressure. In my view, I think that's unlikely to happen. But there is also an exception under the law that the court can, in the interest of justice, order part of what happened before the grand jury to be disclosed. So I think the best shot we would have at that disclosure realistically would be if someone requested it of the court and the court ordered it. That said, in my experience, and I've talked to colleagues who have lived in Kentucky much longer than I have, in their experience, we do not know of a court having done that in the past. One other question that gets raised, so the officer who was indicted will get the grand jury transcript in his case, and in fact, there's a right to it under Kentucky law. If Attorney General Cameron separated out the charges and the cases, then none of that stuff would come in his grand jury transcript. But if he did it all as one case, it's possible that the officer's grand jury transcript would have it. That said, again, I think it is unlikely that the officer would be very interested in sharing the results of that grand jury transcript with anyone in particular. So I think, while there is nothing necessarily prohibiting it from coming out, I mean, there is grand jury secrecy. And so let me be clear that does limit what could be disclosed. There are ways that some of the information could come out. And again, he's disclosed some parts of that information in his press conference. So there's nothing preventing him from disclosing other information about the investigation separate from the grand jury transcripts itself. But in my view, and you guys may disagree with me, I think that is unlikely to happen in this particular instance.
Yeah.
There's another question that I wanted to answer, and don't remember what it was.
Can I just briefly address that issue very quickly? Professor Lawler is absolutely correct. What the prosecutor has ethical obligations to maintain the grand jury deliberation secret so that we don't taint the jury pool. But what's interesting is that General Cameron did make the very clear announcement that the shooting was justified. Now, when you make that statement, you've effectively shut off any possibility of homicide charges later. If there's going to be some new evidence, it's going to have to reach a really high bar to justify some additional charges. And there's a parallel proceeding going on. The FBI is still investigating, and yet the general is saying the grand jury found that the shooting was justified. And once again, we need to look at that evidence and understand how they reached that conclusion. And those kinds of statements are definitely going to take future investigations as well as the parallel investigation.
The one other thing several people have raised is about the execution of the search warrant at night and whether that is permissible. It's actually, fairly normal, I would say, in terms of executing them, and the case law is perfectly clear that that's acceptable. I think the idea is, again, trying to minimize, or purportedly trying to minimize, violence because people might be sleeping, and so it helps the element of sort of surprise and trying to keep people, that's my guess. But the point is that it's perfectly lawful for them to do it in the middle of the night.
It is. Someone asked about other countries. In other countries, there are strict prohibitions on enforcing search warrants in the middle of the night. This is very possible, particularly in Western democracies, which we purport to be. AG Cameron has said that there will be a task force in our community he will call together a task force on these practices. And it's really important when these task force happen that the public send in comments about how they would like officers to behave in just this kind of circumstances. Several people have asked about the issue of rendering aid. And this has increasingly become a question in these cases where you have unarmed people who are shot by officers. So if you remember the Tamir Rice case, we have on video failure to render aid. I don't think there will be any criminal charges that will stem from that in this case, really, or in any of them. But I do think we have to begin to put pressure on those people in power, like the chiefs of police and like our city council people, to come up with some guidelines that more explicitly require that those people, that as soon as possible, you check to see what assistance or aid can be provided for people who have been harmed by the police. Can someone talk about prosecutorial misconduct and whether or not there might be any issues of prosecutorial?
Happy for Blanche to take that one as the former prosecutor on the panel.
It's come up multiple times.
Really quickly, and I know Professor Price is is
Yeah,
thinking in her
really
head,
quickly.
whenever Professor Cook says really quickly, it's got to mean really quickly. The General Cameron made an announcement that Breonna Taylor died within 1 to 2 minutes of the fatal shot. Once again, I want to hear that evidence. Who reached that conclusion? How did we get there? Because that cuts off some of the failure to render aid part of this.
There also, can I insert that in Kenneth Walker's testimony, when he's talking to 911, he suggests that he says in the moment, there are signs of life.
And that's still 2 minutes or 3 minutes after the shooting at that point.
That's exactly right. And so there's evidence that she lived beyond the time that shot was taken.
Again, material issues of facts. People look at the evidence yourselves. Prosecutorial misconduct. Here's the problem. Prosecutors have a ton of discretion in the grand jury. It is not a reviewable decision. This decision by the grand jury can't go anywhere. It can't go to a court of appeals. It can't go to any court in which someone's going to review the decision. There is secrecy to these grand jury proceedings and whether these transcripts will ever be released. You can bet your bottom dollar that prosecutors can use grand juries as political cover when they don't want to bring charges. And when they do, they can always say, well, I gave the grand jurors all the evidence. Well, how did you give the grand jurors? What is all the evidence? You mean to tell me there won't be any future evidence? You gave them every single bit of evidence? What recommendation did you make? What statutes did you read? Did you give them 40 hours of evidence, but you didn't read the statutes that are potentially the chargeable counts, right? Oh, you didn't read the homicide charges, but you did read the reckless endangerment. So there may not technically be an ethical violation, but you've got to understand what happened in the grand jury before you can reach any conclusion about whether justice was done.
And I'll also add to that, I mean, sort of, again, a lot of the questions that we don't know and why people, I think, are asking this question about grand jury, we don't know what charges or they may have been presented with or not. He said repeatedly in the press conference that they've determined it was justified, but that's not something that normally they would be asked to consider because that's a defense. And so, one of the things we know is that, grand juries are not, prosecutors do not have an obligation to give grand juries exculpatory information, any information suggesting the defendant didn't do it. But we saw it in the case of Michael Brown in St. Louis County, where the prosecutors in the police involved shootings will say, here's all the evidence suggesting the person didn't do it. You even heard General Cameron say in the press conference, he has a right to be, about Hankerson, he has a right to be presumed innocent until proven guilty, right? That's not wrong. I mean, he's not telling incorrect information, but the fact is he's focusing on the defensive side of things by saying, again, he said 4 times, I think, to my count in the press conference, that the grand jury determined that the shootings were justified. And I don't understand how the grand jury would have reached that conclusion because they shouldn't have been at that point, so which raises, again, the issue of what they were presented with.
He also says emphatically that the officers were defending themselves, or that they were justified in their shooting due to self-defense, which is also typically not an evaluation that you make outside of the context of a criminal trial before it goes to judge. To say so emphatically seems to suggest the direction in which the grand jury was shifted. Okay, I have 2 quick questions. One is, Blanche, someone wants you to spell paraxis or whatever you said earlier. Just spell it.
Parallaxis. Racial parallaxis is my.
Don't explain it again. Just spell it.
I will read it. P-A-R-A-L-A-X-S-I-S. Use it for gender. Use it for class. Use it intersectionally.
Okay. So now we've had many questions about police reform. And whether or not we see any hope for meaningful police reform, and how might some of what happened in this case have been prevented by the kinds of police reforms that are being called for.
I'll jump in really quickly.
Yeah.
Don't ever underestimate the power of an uprising. The Supreme Court has upheld the constitutionality of dispensing with the knock and talk requirement for decades. But during this uprising, it just took a matter of months for the city of St. Louis to say, you know what, we're not doing that anymore. So don't ever discount the power of political activism to have impact on the law. There's room for all kinds of reform here. There is, if you go and take criminal procedure, you'll hear about the Leon exception, where an officer puts something in the affidavit, that the search warrant affidavit, that isn't correct, but if they acted in good faith, they can still rely on that. Or perhaps we need to revisit Leon. Perhaps we need stricter standards. If you're going to say something in the search affidavit, perhaps there needs to be a different standard of certainty with respect to whether these issues are true. And we also need to evaluate whether the officer has to be lawfully on the premises in order to raise the issue of self-defense. What we're dealing with are ubiquitous problems, and it's going to take ubiquitous solutions. Police reform is just one part of that. There are people who are arguing for police abolition, for prison abolition, and the defunding of the police. You need to look carefully at those arguments. You need to understand what those arguments are. And there's a lot of historical circumstances that inform those arguments. You need to look at those historical circumstances that inform those arguments, and then you make a determination about the viability of those arguments yourself.
So I'll say two things just on police reform, and then try to answer a couple of these questions that have come in just a second ago. But so one is that, you know, there is, as Blanche noted, not lots of sort of talk about police reform, and I think, you know, again, both Professor Cook and Professor Price have alluded to it in the chats in here. You know, there's training on you know, trying to recognize issues with regard to race, you know, but again, Minneapolis was in the middle of doing those trainings, and we've seen how effective that was in terms of what's been happening there. So, you know, police training is part of it. That said, and I hope, you know, he may be listening, I don't mind if he gets called out on this, but, you know, I have some of my students, one of my students is military, and is saying, you know, in our military training, some of the stuff that we get trained, you know, we would never be doing some of the stuff that the police officers are doing here. And so sometimes people who have more experience in more combat zones, you know, when then coming back to a normal city, as somebody had asked a question about sort of the flip side of PTSD with military training with police officers, I think that's a concern. But I think, you know, there are also sometimes when people who have more extensive training in different kinds of settings then come back into your average US town or city, recognize that the kinds of situations that some of our officers on the street think of as being highly volatile are not as volatile, in fact, as they seem to believe, which obviously changes the response. And so, you know, I think that's worth at least putting out there. Let me say a couple things. Somebody asked if we can answer all the questions. We are doing our best. Have been 100 questions, and so I don't know if we're going to be able to get through them all. We really are trying our best to both type.
I'm also typing some answers, and where your question has been answered live, I'm clicking answered live and then moving it along so we can see the other questions that have not been answered. So a question has been raised about violations of police protocol. And why? So there is an ongoing investigation by the Louisville, I forget what they're called, but in Lexington it's called the Police Integrity Unit, which is what they call in the movies internal affairs offices. They all have, their names have been changed in most jurisdictions. Those are still ongoing. So whether or not these officers will be able to continue is still being evaluated by the Louisville Metro Police Department. I suspect that most of them will likely be able to retain their positions due to what Professor Lawler and Cook have explained as the fact that they did not swear out that warrant. They were operating on good faith at the time they were acting. It's also unclear if it was policy at the time that you had to be wearing body cameras for that particular type of action, since some of them seem to have just been called in for extra labor. But a lot of this is really negotiated not in rules around the laws of the state legislature or what the prosecutor does, but in the contracts between police officers and police unions. So I think that all of you should spend some time taking a real look at police unions and union agreements. And in the city of Lexington, we are about to engage in collective bargaining with the Fraternal Order of the Police, who not only represent police officers, but also firefighters and people who work in corrections facilities. And you should bring the pressure or concerns you have to bear on the mayor, who is the representative of the city who sits in on those bargaining agreements. Okay, go
I
ahead.
want to jump in with one. Somebody asked a question about, given Attorney General's justification about, oops, sorry, I just skipped, reasoning of self-defense for the officers. What's the likelihood the same self-defense justification will continue to apply to Mr. Walker? So Professor Price read, I think earlier, the statute. I mean, what it turns on and what was striking about Attorney General Cameron's press conference, he kept emphasizing the fact that there was one independent person who confirmed that they knocked and announced their presence first. The reason that matters is because under the self-defense statute, peace officers, the self-defense statute for protecting your property doesn't apply if it's a peace officer, executing their duties, basically. But the peace officer has to have knocked and announced, or the person inside has to have a reasonable reason to know that that person is a police officer, right? So we know that there was no reason for Mr. Walker to know that there was police coming to the door. I mean, I think that's pretty clear from the evidence that we have, which is why Attorney General Cameron's, emphasis of in his words that it's sort of uncontested. He didn't say uncontested, but that they announced their presence, why that matters. Because again, I think the last number I saw is that there are 12 witnesses who did not hear them announce. There's one witness other than police who are saying that he did announce. And so that's where, again, Attorney General Cameron's framing of the issue, I think, comes into play.
Let me see if I can find us something. What are the differences between how the George Floyd case and the Breonna Taylor case were processed that led to justice being served in George Floyd, but not Breonna Taylor?
Let me say this. Prosecutions are going to change if you have a will to prosecute, if you want to prosecute. If you want to prosecute a case, there's no better place to go than the grand jury, because you have a structural advantage in the grand jury as a prosecutor that the United States Supreme Court has given you over decades. So if you have a will to prosecute, you can get some charges. If you don't have a will to prosecute, you can always say, well, the grand jury decided, the grand jury found. So one of the differences you might see in both of these cases is what is the incentive and the interest in the prosecution itself.
Someone also asked, which I can't think of any cases where I have any knowledge of it, how often are police officers actually prosecuted for the killing of unarmed Black people?
It is de minimis. It is a small fraction. It is a small, I wrote an article about this, bias and broken. Am I hyping my own scholarship in the middle of this talk? You betcha. It's called Biased and Broken. I actually broke out the statistics. It is a very de minimis amount of officers that are ever charged in these cases.
And then when they are, part of the reason, I mean, there's lots of reasons behind it, but when they are very rarely convicted.
Yeah.
What about body cameras? I think we've touched on this a bit, but do you have any specific comments on with the proliferation of video cameras, why they aren't required? So I'm typing and answering these questions, but I believe someone asked about why they didn't have them turned on. The city of Louisville actually reformed its rules around body-worn cameras in the wake of this case, in part because during one of the protests where protesters were injured by police officers had turned off their cameras. The city of Lexington has made, some of you may know that I was on a task force that was organized by the mayor. So I know that the city of Lexington is actively reforming its policies around body-worn cameras to expand it to include all officers, which it did not include in the beginning. There is you often hear police departments claim to say that the expense becomes prohibitive because you have to store all of this footage. But we know that there clearly is a shift towards increased use of body-worn cameras, and how do you make that? The question then becomes, what do you do with all of this footage once it's there?
I will also say that it's something that has been put out as a legislation that could be passed by the state, and I would encourage you to write your legislators to ask for legislative reforms related to police misconduct. Some of them, again, involved increased use of body cameras, but again, you have to be careful just to make sure that they also clarify when those body cameras have to be worn, when they have to be turned on, some of the storage issues as well. Ending the use of no-knock warrants, which we've talked about before. Louisville changed it. The state of Kentucky still has not, right? We could have a state law that prohibits the use of no-knock warrants, right? So some of those legislative proposals are in the process of being proposed right now. And so writing to your legislators and helping to make them know that that's an important priority for you on some of these legislative reforms, I think is another thing to make sure to keep in mind.
There's not a lower standard for peace officers when it comes to self-defense. There is some discussion as to with anybody who's engaging in self-defense, you can't just defend yourself Rambo style, shooting off and around. You should defend yourself, and this should be directed towards a specific attack. But there is a lot of credibility or credence given to the word of law enforcement officers when they claim self-defense that can make it hard for individuals to overcome the presumption of prosecutors and often jurors that they were not actually engaging in the defense of themselves. Do either of you have any comments on what the FBI investigation might yield?
I suspect we both think that it might yield some issues with regard to the search warrant.
Yeah.
But go ahead.
Here's part of the problem. We've already got the comment from the general that the shooting was justified. That's really going to put a lid on future prosecutions. The FBI investigation is still ongoing. The FBI gets to investigate not only this case, but the operations of the police department, which is what you saw in the case involving Michael Brown. Now, under the current administration, there's going to be a question about how far that Department of Justice investigation is going to go and turning up systemic problems in the police force. But it's quite possible that they go in and do a full investigation and outside of this incident itself, unearth other kinds of problematic behavior within the police department.
Mm-hmm. So there are a lot of people who are listing resources about this case in the chat about things you can read. So you might scroll through and look to see about articles on police unions. It's not clear. We have no proof that the police union put any pressure on the Attorney General to protect the police, but we do know that he was endorsed strongly by them in his bid for the Attorney General's office. But I do have to say that there is often one of the reasons that some jurisdictions have made rules that take cases that involve officer shootings away from local prosecutors is due to the belief that their relationship may be too close for the local prosecutor to have an objective view of the evidence that is before them. And I think part of the concern and the disappointment in the findings of the Attorney General is that this also suggests to citizens who believe that this was an unjust killing, that even removing it from the local arena does not take away the politics that favor police officers in such incidents.
Very quickly, if you're looking for resources, Paul Butler is a law professor at Georgetown. He wrote a book called Chokehold. Also on his Twitter feed, he has done opening arguments of what could have been an opening argument if you had a will to prosecute in this case. He's also a former federal prosecutor, now law school professor. Paul Butler, Chokehold.
Can you talk a little bit about both the Attorney General Cameron and Attorney General Barr, which you alluded to before when it comes to federal charges? And someone asked, does the Attorney General have to have had some experience in this area of law? So you do not have to have had any criminal practice in order to be the Attorney General. The Attorney General at most state level is an elected office, and the Attorney General at the federal level is appointed. But every Attorney General's office has some lawyers who specialize in criminal law within their offices. But the Attorney General sets the tone for what kinds of cases they will take and the approach they will take to prosecution. Okay.
I want to answer one question.
Go ahead.
in here real fast, just because I think maybe we made the presumption that everyone knew this part of it.
Okay.
It asked, why was Officer Hankinson the only officer to receive charges of wanton endangerment? We had a couple of
Cool.
versions of that question. If the other two officers were involved in the shooting, Officer Hankinson, for whatever reason, went back out and into the parking lot and started shooting indiscriminately into the building, and so it was. I wouldn't say almost, but it was almost beyond dispute that he probably would have been charged in the case because he was not basically following protocol. He was not, shooting, to try and stop whatever the shot was that he had heard fired. And so he is charged, and he's charged again. Why he is charged with 3 counts. I mean, it has to do with where the bullets landed. Seems to be in the apartment behind Breonna Taylor's apartment, apartment number 3. The question of why the other officers weren't charged has to do with the self-defense stuff that Professor Price and Professor Cook have already talked more extensively about. But I think we may have presumed that everybody kind of
Yeah.
understood that part.
So excuse me, but I have to go. I actually have to be on another panel
She has
right
to
now.
speak. So Professor Lawler and I will take another 10 minutes, and we will continue to get in as many questions as we can. Is there any way to audit the Attorney General's behavior aside from the next voting cycle? We have very little discretion and oversight over any decisions of prosecutors that they make, particularly when it comes to their professional judgment around charging and how to make arguments, about the grand jury.
There are a couple questions also that I think I answered earlier in the presentation. So
Okay.
regarding the issue of the knock and announce versus no knock, it was initially a no knock warrant. They did, they said that they knocked and announced. Obviously there's conflicting testimony on whether they actually announced or didn't announce, but they technically had a no knock warrant earlier that day. Superiors had decided that it should be executed as a knock and announce. One of the things to clarify, I answered this to one person, but the knock and announce generally, you do not, it's not like, oh, you knock and announce and you sit there and wait for a while. The law, Supreme Court has said it's fine if it's basically under a minute, several seconds when you knock, and so it's not like, as we would think, if you knock on the door and you wait for someone to come to the door, you're going to wait for a little while. The law allows them to go right in if they haven't heard anything within basically, I think, like a minute or so.
So people are asking a lot of questions about what can you do if you're interested in certain reforms. So there are a couple things that I think that are trending around the country about what you can do. One is the trend towards the election of reform-minded prosecutors, or prosecutors who take have a more understanding of systemic racial inequalities within the criminal justice system, and then create policies within their offices in order to help alleviate some of those concerns. Local elections matter. So when we have a election for judges, when we elect the prosecutor, when we elect the sheriff, when we elect any number of elected officials on the local level, you should be there asking them questions about these very issues. The other thing is that most of you are residents of the city of Lexington. The mayor is now considering a report issued by a task force put in place around racial inequality. You should write your city council member and the mayor and ask them to take these proposed reforms seriously and enact them where they're possible. Do you have any other things people might do?
Again, I think, Melinda's talking about it. Sorry, Professor Price is talking about it more at the, local granular level. I would just say also, again, there are things happening at the state reform level as well. But I also think, some of my students have been out protesting, and I think Professor Cook's point is well taken in that, if that's something you feel comfortable doing. I know for many of us, it's a little bit more challenging in our COVID era in terms of what our comfort levels are. And some people are not comfortable protesting in any era. But, if that's something you're comfortable with, if you feel strongly about it, I mean, that again, we've seen already in Louisville that effectuated change in a very short amount of time in terms of the no-knock warrants that got, banned by the city council. And so, there are different routes. Some of them are more structural. Some of them are behind the scenes. Some of them are more, upfront and on the street. So, I think, take the routes that feel most comfortable to you and trying to effectuate the changes that you believe need to happen. And I think part of you, I mean, some of the people who are asking these questions are law students. Part of the reason you can go, you go to law school is to be able to learn what the law is and to be able to try then and effectuate change in many different mechanisms and many different roles in your.
What would you say to someone who thinks justice was served?
I saw that question. I don't have an easy answer for that. I am certain that I know people who feel that way,
Mhm.
but I don't have an easy answer as to how to address that interpersonally. I think it's um, I think reading some of these things, I think partly that's, I think the more information people have about the systemic issues that our criminal legal system has, the more they may understand why someone might not feel that way in this instance. But how, in terms of disvaluing human life, I don't, I don't know that I have an easy answer to that.
It's also, I have to say that my sister wrote an op-ed in the New York Times. It should be in the print version. I have a twin sister, so it wasn't me. In case you saw that article, and one of the things she said is, with every one of these cases of unarmed shootings of Black people, there's always an explanation, right? You should have complied with the police. Why didn't you keep your hands up? What is the lesson to be learned here for Black people about how to be safe in their homes from this case? What could Breonna Taylor have done to have changed? Like, what was the thing she should have done? Trayvon Martin should not have been out at night. Tamir Rice should not have been playing with a gun, a toy gun in a park. What is the thing that she should have done? And we also need to make a distinction between legal outcomes and justice. And sometimes those things overlap, and many times they do not. And it's important to remember that this is a legal outcome. And what the family members have said, what people in their communities have said, and what member people in our community have said, is that this doesn't feel like justice to them. And where there is a disconnect between legal outcomes and justice, there should always be questions about how we move those two things closer together.
Yes.
Always. Whether you believe the outcome was just, but when people disagree with you, there should always be some discussion about how to bring those things together. Do you have any closing remarks as we bring this to an end?
No, although I did want to address just one question that also
Go ahead, feel free.
about the grand jury demographics. There is nothing in the law that prohibits him from releasing the demographics. That's a matter of choice. There's nothing that is not covered by the grand jury secrecy provision of the law, the demographics of the grand jury. No, again, along the lines of what Professor Price was just saying, I think that's really the key here is that, I think many people, both locally and nationally, hoped for a different outcome because it's the just outcome that, that we're looking for. And, because of some of these different structural flaws in our legal system, it wasn't necessarily the outcome that the law ensured would happen, right? I mean, there were ways to get out of the just outcome that many of us felt should have come from the legal process. And so I think, again, trying to focus on thinking about things both outside the law in terms of change, but also in trying to bring the law closer to justice is really the key here. Because again, many of us were not particularly surprised, even though we were very disheartened by the Attorney General's decision, or the grand jury's decision, I guess, but sort of both together. But that doesn't mean it's the right call, right? It doesn't mean it's the right decision, and certainly, the idea that one of the members of our society could be lying in their own bed, asleep, and be killed, having done nothing but be asleep in their own apartment, is very troubling for a lot of us. And so I think trying to think about ways to challenge that.
One of the questions that are raised is that someone mentioned that Breonna Taylor's family has asked that why not have law enforcement who live in your community? And people love to talk about the woebegone days when your officer lived down the street. I grew up next door to a police officer who I knew very, very little, but he was always there. And why not? Well, there was a Supreme Court decision about whether or not the cities could require officers to live within their jurisdiction, and the court said it could not be a condition of employment. So it's not that people don't want officers who live in their community. It just cannot be a requirement any longer. So we would like to thank you for participating in this. I mean, if you have ever wanted to see law professors tap dance, this is as close as you will ever get to seeing it. And some of your questions we did not get to. For those of you who are students, please ask us these questions that you may have remaining when it comes to class. You can also reach out to the panelists if you have specific questions by email. And for those of you who are in the community, we thank you so much for attending. And we just ask that you all pay very close attention to the conversations that are being had in your community, not just about police reform, because everyone can point to, in this instance, quickly what might be the concerns about the behavior of the police, but also what is your mayor and your city council? What is the police chief's response? What is the state legislature going to do in response? And I can pretty much guarantee you that it will not be in favor of those who find themselves in beloved relationship with people like Breonna Taylor. And also think about the fact that we have an election coming up. So everything matters, and how you participate and don't participate is up to you, but we just ask that you are fully engaged so that when decisions are made, we at least know that we have done our best to push the needle or to push the frontiers of justice closer in the right direction by the actions we have taken. And that is not a consistent forward motion, but it comes from the steady pressure of individuals like yourselves who continue to do that kind of work. Thank you so much.